It is Friday. I have really enjoyed spending the week with all of you. And I mean that, I do mean that. But I hope that we can get through everything today. We're gonna head into confidential session in just a minute. But are there any housekeeping matters that we need to deal with before we go into confidential session?
Yeah, so there's one matter on behalf of the village. When Miss Perry was called to testify, we presented an exhibit, which was Village Redirect Exhibit 3, which purported to identify an error in the calculation of tax. Upon the public staff's testimony, we revisited those calculations provided by Mr. Taylor, and we are retracting our position that the tax was calculated incorrectly. And we wanted to make the commission aware that we identified our error. And hopefully that might eliminate a need of kind of drawing that out on testimony. So we just want to go ahead and fess that up.
Okay, so I'm not following what you're saying. Do you want to withdraw the Village Redirect Exhibit 3? Withdraw the correction.
So the exhibit was a purported correction to the calculation of tax. It turns out we no longer believe the tax was needed to be corrected. And so, yes, I think it would make sense to withdraw the exhibit.
Withdraw it. Okay, so without objection, that exhibit will be withdrawn. Good. Okay, and Ms. Hawkins, do we want to address the additional proposed documents for admission, the Sharp View responses to public staff data requests?
Not at this time, I don't think.
Okay.
Thank you.
Yes.
Chair Mitchell wants to ask the point of clarification. Well, yep. So we'll come back to that on the break. Okay, so Mr. McCoy, if we could head into confidential session, please. Chair Mitchell has a clarification question.
So we've had 4 documents admitted to the record. BHIT, public staff cross-examination, exhibits 1 and 2 that you just moved in, and then Village Perry redirect examination, exhibits 1 and 2. Are those the same document?
No.
Are those the same documents?
No.
I know you've withdrawn 3.
Yes, I believe they're they're
Okay.
the same documents. The formatting might be slightly different, but they're both Mr. Taylor's work papers. I think mine version was one of them's landscape versus portrait,
Yeah.
but they are the same numbers.
Okay, I just
Yeah.
for purposes of the record, I want to make
Okay,
sure.
thank you. I just was thinking that your redirect exhibits might have had some of the correction columns in it, but it was not.
No, we provided the 2 original work papers, and then we had the 3rd exhibit, which we've since withdrawn.
Okay, all right, thank you.
Okay, thank you.
Okay, Mr. Stires, we're back on rebuttal.
Per our discussion at the end of the day, we're going to go a little bit out of the sequence, and given Mr. Taylor's travel schedules, we'd like to call now as rebuttal witness, Mr. John Taylor.
Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name, address, and employment for the record.
John Taylor, I'm a managing partner of Atrium Economics. The address is 10 Hospital Center Commons, Suite 400, Hilton Head Island, South Carolina, 29926.
Have you caused to be pre-filed in this docket rebuttal testimony consisting of 13 pages in question and answer format?
I have.
Was the testimony prepared by you or under your direction?
It was.
If you were asked those same questions today, now that you're under oath, would you provide the same answers as in that pre-filed testimony?
Yes, I would.
Do you have any corrections or additions to that testimony that you pre-filed?
No, I do not.
Okay. Was there one exhibit identified in and filed concurrently with your rebuttal testimony?
Yes, there was.
Did you also prepare 2 spreadsheets quantifying your testimony on page 24 of your testimony that have been admitted to evidence in this docket so far as public staff cross-examination exhibits 1 and 2, BHIT cross-examination exhibits 1 and 2?
Yes.
Okay. At this time, I would ask that the pre-filed rebuttal testimony of John Taylor, consisting of 32 pages in question and answer format, and the 1 exhibit be admitted into evidence at this time and in the record.
The rebuttal pre-filed testimony of John Taylor will be received into evidence and treated as if given orally from the witness stand. As for the exhibit, it will be identified as pre-filed at this time.
Have you prepared a summary of your pre-filed rebuttal testimony that has been filed in this docket?
Yes, I have.
Okay. Is that summary true and accurate to the best of your knowledge?
Yes, although there is 1 edit that needs to be made.
Okay. Where would the 1 edit be? And that testimony, I think, has been circulated to everyone. You should have that.
So the last page on page 3, the last sentence of the first paragraph.
And what's the change?
Yep. The term reasonable was duplicated. It's in the sentence twice. The sentence should read, in contrast, following the logic recommended by the village's witnesses would require rates to be lowered significantly below the current reasonable rates, considerably decreasing the value of those assets and jeopardizing the financial viability of the entire enterprise and the transfer.
With that 1 correction of striking the word reasonable, the second time on next to the last line on the first paragraph on page 3, is your summary true and accurate?
Yes.
Okay. So we would ask that the summary of Mr. Taylor's testimony also be, which has been filed, would also be included in the record.
The summary will be received into evidence at this time.
Thank you. And the witness is available for cross-examination.
Thank you.
Mr.
Good morning,
Farrell.
Mr. Taylor.
Good morning.
Craig Shower on behalf of the village. The applicants hired you to provide expert testimony on the proper treatment of acquisition premiums for the transportation system, correct?
That was one part of my engagement, yes.
You've testified in about how many proceedings?
I think 37 or 38.
But you've never before testified or provided expert testimony about a transportation system, correct?
I have not.
If I could interrupt for a second, Mr. Gardner, is he still outside thinking it's confidential or is? Okay, but he knows to come back in. Thank you.
I'm sorry, so you've never before provided expert testimony about a transportation system?
Correct.
All right. And you've never before testified in a regulatory transfer proceeding?
I've provided expert reports related to the transfer of regulated utilities, but have not been the primary expert witness in those proceedings. Namely, Puget Sound Energy was sold to Macquarie, which was a $7 billion sale. I worked on that. Bay State Gas, sale of Northern Utilities to Northern, as well as the acquisition of Gas Metro, acquired a couple utilities in Vermont. I worked on the NICOR AGL merger and the analysis related to the implications of shared service cost, as well as worked on the divestiture of independent power plants, including 2 nuclear facilities.
All right. And even though you worked on those proceedings, you were not providing testimony?
Correct.
As part of discovery, you produced some calculations of the impact on rates as a result of including the acquisition premium and rate base, correct?
Yes.
Right. If I could direct you to what's been marked as BHIT Public Staff Cross-Examination Exhibit 1 and BHIT Public Staff Cross-Examination Exhibit 2, these are the 2 work papers that we just discussed. Do you have copies of those?
Yes, I do.
All right. I'd like to focus on parking. That's okay?
Okay, that would be the Exhibit 1.
Yes. Thank you. And I just realized I had marked both as Exhibit 1, so appreciate you telling me that. Looking at lines
Mr.
6,
Shower, this is
Sorry.
a confidential exhibit. Are we going into confidential information?
I don't, it's not marked as confidential.
Could
I
we-
do not know.
Could we go off the record for about 1 minute recess to address that?
Okay, we're gonna go off the why are we going off the record?
We'll have a 1 minute recess to talk to my client about that.
Yes, we will take a 5-minute recess.
Thank you.
Mr. Shower, do you want to identify an exhibit?
Yes, I do. I'd like to identify two exhibits, if that's okay. The first one is titled at the top, Calculation of Rate Impact Dash Parking. I'd like to identify this as Village Taylor Rebuttal Cross Exhibit 1.
It'll be so marked.
The second exhibit has the title Calculation of Rate Impact Dash Barge at the top. I'd suggest we title that Village Taylor Rebuttal Cross Exhibit 2.
The only, we appreciate the recess so we can clean this up and having,
Hold on a second, and that'll be so marked.
Thank you.
Go ahead.
so we appreciate the recess so we can address this. And I've also talked to council. And I will be the first to admit it was my mistake that these have not been marked as confidential.
No need. Let's just move forward.
We'd like to mark these as confidential, attorney's eyes only. To the extent that they contain the purchase price for the transportation assets and the estimated allocation. Ms. Boswell's testimony did not reference any numbers. So her testimony is fine on the record. But we would ask that these two exhibits, Taylor Cross Exhibit 1 and 2, and I will work with the court reporter to ensure that the public staff, BHIT public staff cross-examination exhibits 1 and 2 also be
Mark
confidential,
confidential.
and that the Perry redirect exhibits also be marked confidential and treated as such in the record. And I'll work with court reporter to ensure that. And we appreciate that accommodation.
Okay, so I accept your motion, and that is allowed, and we will treat all of these exhibits marked as confidential. Mr. Stires will work with the court reporter to have the transcript appropriately designated, and so that the commission can appropriately treat these as confidential exhibits.
Likewise, if there's any, I don't think there's references in Mr. Taylor's testimony, but we'll also work with the court reporter and with the clerk to ensure that the confidentiality is retained on those numbers.
Okay, thank you, Mr. Stires.
Thank you.
Yes, Madam Chair, understand an inadvertent disclosure, but I just would point out that this information has been in the public domain since February 27. Don't oppose the treatment, and again, understand that, but just would point out that it has been out there. So, you know, I know people are reading these documents and they're monitoring the hearing, so.
Understood. If there's, thank you. I mean, I acknowledge that.
Okay, Mr. Creech?
We have no objection to the applicants.
Okay, let's move forward.
All right. Mr. Taylor, do you have the two calculations of the impact on rates in front of you?
Yes, I do.
Okay. I'd like to start with the parking calculation, which is cross exhibit 1. Oh, sorry. Commissioner Duffley, given that these contain confidential numbers and we're going to go through the numbers, I do believe we need to go into closed session though.
Mr. Stires, can you explain that these have been disclosed? It's been in the public domain.
I think this, Mr. Tratham was referring to the testimony of John Taylor.
Yes, on page 20 of Mr. Taylor's testimony, these figures are stated and have been part of the public filing.
I can't unring that bell, but we would ask that, we would ask then that going forward, that my correct be corrected, and that this hearing testimony transcript not reveal these numbers.
Okay, so we need to head into confidential session, Mr. Shower. Is that what you're stating?
Based on the questions I have, yes.
Okay, so Mr. McCoy, we will go with, Mr. Higgins, you stated you had some non-confidential questions.
Yes, thank you, ma'am. Mr. Taylor, turn if you would to page 16 of your testimony. This is just a cleanup item, I believe. Page 16, line 23. Are you with me?
Yes.
I'm sorry, I said line 23. I meant line 12, page 16, line 12. You state there, as I mentioned earlier, the rate of return Sharpview will be allowed the opportunity to earn on regulated operations relates to, and it continues from there. Would you agree that Sharpview is not going to be a regulated utility entity?
I don't know if I can make that determination. From my understanding, commissions have regulatory oversight of holding companies and affiliates. I don't know to what extent, but I would say that Sharpview as investor manager would not be a rate regulated utility.
Right, trying to understand the basis on which you're suggesting that the commission would set a rate of return for Sharpview.
It's a good point, Mr. Higgins. I think the intent was on Sharpview's rate regulated entities and operations.
So subsidiary entities that were the actual operating utilities.
Correct.
All right, sir. Move on, if you would, to page 18. You and Mr. Shower had some extended conversation about depreciation. Do you recall that Mr. O'Donnell's testimony made the statement that the depreciation rates used by Baldhead Island Limited, the current owner of the parking and barge assets, were comparable to those used by the public staff?
I don't actually. I'm happy to accept that subject to check.
Fine. Have you been to Baldhead Island?
No, I haven't.
You couldn't get a visit out of this assignment?
The engagement has been long enough.
So you've never ridden the ferry?
I have not ridden that ferry.
Okay. You used the term competitive enterprise several times in your response to council's questions. And you made the statement on page 22. Let me give you a reference. I think it's line 19. Yes, line 19. You make the statement to something Mr. O'Donnell said by pointing to the fees that have been charged with respect to a competitive venture. You used the term in responding to Mr. Shower's questions, a competitive enterprise. Are you suggesting that there is some competitive option for people parking their cars to ride the Baldhead Island Ferry?
I really haven't evaluated the competitive nature of the parking operations. I wish I had the opportunity to be engaged on sub 21, but I was not.
We accept subject to check that in the sub 21 order, the commission said, and I'm going to quote from finding of fact number 5, that there is no existing alternative or reasonably substitutable parking facility or service available to the public, close quote.
Again, I haven't reviewed the record and have no reason to disagree with that commission determination. As it relates to my review of sub 21, it was predominantly to understand the nature of the order as well as the conclusion that the parking rates were deemed to be reasonable.
So on page 22, lines 19 and 20, when you make reference to the market conditions, you're not suggesting that there is a competitive market for the services offered by Baldhead Island Limited in terms of either parking or barge, are you?
I didn't review the all of the information related to the competitive nature of parking or barge services that might have been offered in sub 21.
All right, sir. I don't have any other questions for you. Thank you.
Thanks.
So real quick if I can, and I may have misheard you, so I just wanted to correct, see if I heard this correctly. I think you were speaking of maybe a parking rates, but I thought I heard you indicate that there was some level of agreement among the parties that the purchase price for the entire, under the APA is fair and reasonable. Did you mean to indicate that?
What I was intending to indicate that it was a price in which the seller was willing to sell and the buyer was willing to buy.
Right, thank you. And this kind of goes into your statement relating to prices, your reference to earlier testimony about prices exploding. And obviously, we know during the pandemic, a lot of folks flocked to wonderful places like Baldhead Island. And but since this, would you accept that interest rates have risen fairly substantially since this asset purchase agreement was entered into in May of last year, and that there is a correlation between price and interest rates and demand for real estate?
I would agree that there has been increases in interest rates. I mean, as a student of economic history, looking at interest rates over time, over the last 50 years, while there's been increases that have occurred recently, I wouldn't consider them overly substantial, but there is a relationship there, yes.
Would you accept, subject to check, that those rates have increased by approximately 3.75% since the date this APA was originally signed? Does that sound reasonable?
That does sound reasonable.
All right, thank you.
Redirect. I'll take that as a
Yeah,
no.
no, I'm sorry. I'm sorry. I'm just, knowing this is my last chance, I'll make sure. I do have a few, if I may, and I realize we're trying to move forward.
Move on.
I do appreciate that very much. I'm trying to figure out how to make this as efficient as possible. We do have one redirect exhibit. It's non-conference redirect exhibit, and I'll ask Ms. Hunter to she'll distribute those. I'll try not to approach just to ask the question, but Mr. Shower started to refer to page 28 of the order in sub 21, because you have said that you understood that the sub 21 order indicated that rates were reasonable. That was your interpretation. And I would refer you to the bottom, the last line of the first paragraph on page 28. And there, the commission stated that the great weight of the evidence shows that at present, the parties are generally satisfied with the current rates and services of both BHIL and BHIT, as well as the agreement they struck in the last general rate case involving parking, involving the parking operations. Is that correct?
Yeah, I recall that.
So that sentence refers to the last rate case, the testimony in sub 41, A-41 sub 7. So let me go there in just a moment, but to set the stage here, your calculations show that fully rolling in the fair market value purchase price of the parking would result in a small decrease in parking rates. Is that correct?
Yes, no material change.
Yeah, very small. So it was at 50 cents. Have you looked now, since Ms. Perry's testimony yesterday, have you looked back at Mr. Jim Hord's testimony from the A40?
Yes, I did review that testimony.
And so we would ask that the testimony of Jim Hord filed on September 30th, 2010, be marked as redirect exhibit 1. Yeah. 1, thank you. Having reviewed this last night, did you see that Mr. Hord testified about the effects of rolling in all of parking financials into rates and what that would, effect that would have on ratepayers?
Yes, I was curious about that after Ms. Perry's testimony, so I reviewed it.
Let me refer you to page 4 of that testimony.
Okay, I'm there.
All right, and would you read the sentence starting on page 8, line 8, excuse me, with had the parking?
Had the parking facility been reflected in revenue requirement on a fully rolled-in basis, the full amount of parking revenues would have been offset by the pre-tax rate of return on the parking facility rate-based investment, depreciation expense, operation and maintenance expenses, property taxes, and payroll taxes. In my opinion, the revenue requirement impact of reflecting the parking facility on a fully rolled-in basis would have been considerably less favorable for ratepayers than the stipulated adjustment.
So based upon Mr. Ward's testimony, that the order will reflect, was relied upon by the commission in the rate case order, depreciation expense, parking operations and maintenance operations, property taxes, payroll taxes were not part of the imputation. Is that correct?
Correct. They were not part of the revenue requirement.
And finally, Mr. Shower handed up to you rebuttal cross exhibit 3, which is 62-133, how rates are fixed. Do you see that exhibit?
I have it in front of me.
Okay. And let me refer you to the second page of that, subsection D. And because he referred to subsection A4, but with regards to the commission's authority and what they consider in determining reasonable and just rates, what does subsection D state?
But I actually underlined that. I didn't get a chance to bring it up earlier, but it says the commission shall consider all other material facts of record that will enable it to determine what are reasonable and just rates.
So they're not just limited to certain numbers, is that correct?
No, from my experience in, across North America with utility commissions, they have a pretty wide leeway in determining what they conclude is just and reasonable rates.
No further questions on redirect.
Okay, commission questions on the non-confidential questions. Seeing none, do we have questions from the confidential session? One confidential question? Okay. Sorry, Mr. Gardner. It's going to be quick, though. for testifying today. We appreciate you coming to Raleigh. You may want to try to get back and actually see Bald Head Island when next time you come to North Carolina.
I will, thank you.
So we are at 12:24. Well, let me go ahead and take motions first.
Thank you. The village, Commissioner Duffy, the village would like to move into evidence 3 exhibits, which are Village Taylor Rebuttal Cross Exhibits 1, 2, and 3.
Okay, without objection, that motion is allowed.
Commissioner
And
Duffy, if I could apologize, I just realized Exhibits 1 and 2 are confidential.
And those will be marked as confidential.
attorney's eyes only.
Treated as such, attorney's eyes only.
And BHIT would ask that Taylor rebuttal redirect Exhibit 1 also be admitted into evidence.
And that motion is allowed. And did he have an exhibit to his testimony
Yes.
as well? And that shall be introduced into evidence at this time as well.
His CV, which is attached to his pre-file. That's correct.
Okay, so it is 12:25. We have Mr. Stewart in the audience.
Yes.
How much cross do we anticipate for Mr. Stewart?
Village will waive cross for Mr. Stewart.
Okay, waving cross. Mr. Higgins?
In light of that, the club will as well.
Wonderful. And public staff?
We had one question in particular.
Okay, okay. So, Mr. Stewart, come up and be sworn, please. We'll take care of this before lunch. Left hand on the Bible? Or do you want to affirm or?
Just affirms.
Okay. Do you affirm that the testimony you're about to give shall be the whole truth, and nothing but the truth? Okay, Mr. Cruz, sorry.
That's all right. Thank you. Mr. Stewart, can you please state your name, address, and position of employment for the record?
Byron Stewart, employed by Bald Head Island Transportation. Address is 1301 Ferry Road, Southport, North Carolina.
Have you caused to be pre-filed in this docket direct testimony consisting of 18 pages in question and answer format?
Yes.
Was that testimony prepared by you or under your direction?
Yes.
If you were asked those same questions today, now that you are under oath, would you provide the same answers as you provided in your pre-filed testimony?
Yes.
Do you have any corrections or amendments to your testimony?
I do not.
All right. And have you prepared a summary of your pre-filed testimony that has been filed in this docket?
Yes.
And is that summary correct?
Yes.
At this time, we would ask that the pre-filed testimony and the summary be admitted into evidence.
The rebuttal pre-filed testimony on Byron Stewart will be received into evidence and treated as if given orally from the witness stand, and the summary will be received into evidence at this time.
Thank you. The witness is available for cross-examination.
Captain Stewart, I just wanted to confirm, and you talk about it briefly on page 12 of your testimony about your possible future employment with the operation. Can you speak to the current status of any agreement that you might have? Will your role be the same as it has been with the existing operation, that it will be with the future operation? Those two things.
My understanding and conversations with Mr. Roberts is that I will be offered the opportunity to remain on board. We have not set specific timelines, but the general guidance of about 3 years for transition with the opportunity to remain on has been agreed to verbally, at least notionally, based on our discussion. There's the understandings I remember remain as the COO overseeing operations. We did not get into details about any other titles that might be associated after the transfer.
And you're familiar with the filings made by the applicants in this docket that relate to regulatory conditions for the 90% on-time performance with some caveats relating to force majeure and things like that. Are you familiar with that?
I am.
And how do you feel about that metric?
So there's been a lot of discussion about on-time performance. It seems to have been established as a litmus test for the effectiveness of the ferry system. I would argue that that's an incomplete measurement. The key objective and the key goal that we should have as a transportation system is that every person who steps on the ferry walks off the ferry in the very same condition. They may be a little wetter, but they walk off in the very same condition. My priority is to make sure that we follow the procedures and processes, that we validate operational procedures to the extent that we minimize risk to the rider, to the vessels, to the crews. If your entire measurement of effectiveness is based on whether you depart within 2 minutes of a scheduled time, that is a unreasonable pressure to that may cause people to cut corners and to not pay full attention to safety protocols, to make unnecessary risk decisions in operating the vessel. And so I acknowledge that on-time performance is an important metric in terms of managing expectations for the riders. There's been testimony about flights and things like that, and I fully understand that, but not at the cost of passenger safety. And we focus primarily on passenger safety, the experience that the rider has while they're on the vessel should be, again, safe and efficient. And we try to meet that objective every single time. What I would say with regard to the standard is it's certainly reasonable to set that standard as an expectation, but I would argue that there were a lot of other measures that need to be contemplated when you evaluate the overall effectiveness of the system.
And do you believe that the carve-outs that the applicants have suggested to that metric are allow for safe but also reliable service?
I believe so, but I do say that, 90% in any transportation system is very difficult to achieve because of all the various variables. That's not saying we can't try to achieve it, but that's a pretty difficult standard to achieve.
All right, thank you.
Particularly at a 2-minute interval. That is the hardest part.
All right, thank you, Captain. No more questions.
Just very short redirect. Mr. Stewart, if the condition says that holdings in BHIFT shall have a goal of on-time ferry departures of 90%, excluding delays caused by certain things, is that a goal that you're willing to work toward?
Absolutely. I'm not arguing the goal. What I guess the implication in the proceedings and some of the testimony I've heard is that the system is substandard because we can't meet 90% departure time. And I just think that that's not a very complete evaluation of the system as a whole. It indicates, I think it insinuates problems within the system that do not exist.
Thank you. Nothing further.
Commission questions? Chairman.
Good afternoon, Captain Stewart. Thank you for being here with us today. Just a few for you. I'm interested in your testimony on the New York City ferry system and the Washington State ferry systems. But before I ask you my specific questions, how did you inform yourself about those two different systems? Did you do research on the systems, or how did you come into the knowledge that you've expressed in your testimony?
So I've been exposed to the systems operationally in my work with the Coast Guard. Now, on the financial side of it and the standards that they use for measures, those are publicly available.
Okay.
Basic internet search.
So you just were able to find this information related to their budgets and passenger counts, et cetera, is available on the internet?
Yes,
Okay.
Commissioner. The one challenge, the New York City ferry system budget is very difficult to identify. The numbers that I quoted in my testimony were available publicly when I originally drafted the testimony. Since that time, you may have seen articles about the New York City ferry system with regard to unaccounted expenditures to the tune of nearly $250 million. So it doesn't surprise me that some of the previously available, publicly available information on their budget has been pulled down from the internet.
Got it.
A
Okay.
deep dive into the DOT budget revealed a slightly different number of around 140 million.
Okay.
But that's kind of how I researched those dollar figures.
Okay. But the point remains, sort of irrespective of the issue with the New York system, New York City system, that both of those systems, both the Washington State and the New York City system, receive state and federal funding in addition to revenue generated through ticket sales.
That is correct.
Okay.
And both systems have a largely subsidized ticket. So revenue generation is not necessarily consistent with OE expenditures or capital requirements.
Got it. On page 17 of your testimony, you indicate that the New York City ferry system budget supports $16 per passenger. And that's based on 2022 numbers. And then you compare that to Bald Head's 2021 data, which would support a $10 per rider. What is that? What's significant about that? What should this commission take away from that comparison?
So it's significant to me, and I'll preface with, I spent a lot of time working federal budgeting, agency budgets, defending budgets on the Hill. There's no question that operational requirements and operational situations are important to the performance of any system. But what can help mitigate risk, and when you're talking about something like on-time performance, workforce management, workforce hiring and recruiting, recapitalization of assets and long-term sustainment of those assets, capital and otherwise, money is a factor. And when you look at per rider investment to mitigate some of those variables that are outside of your control, then you have a greater opportunity to meet all of those goals, including something like on-time performance. Now, that's not the panacea. Money is not always the panacea. There's certain things that are never going to be ever overcome by an investment, but it is a good indicator of the resources available to mitigate impacts to a system over time and in emergent situations. And so when I looked at the available resources of the Washington State and the New York City ferry systems, it was very clear that they do have additional resources that we do not have access to. Some of it, and also what is interesting to note is those budgets are also subject to supplemental funding. When they run into a situation that requires additional expenditures, whether it's capital or otherwise, the government has the ability, the system has the ability to go to state government or petition the federal government for additional grant funding to make up those gaps. That access to those kind of resources it's not something that we have available. When we suffer a major casualty, that's taken out of hide, essentially, for lack of a better term.
You said taken out of hide. Got it. Just want to make sure the record is clear. The sort of following along this line of conversation, you've obviously understand the position of the Mitchell estate, which is that it's no longer in a position to make significant investment in the system. Given that you're the operator of this system, given the complexity of the system as you've testified to, and as we as the regulator understand, what is your reaction to the Mitchell estate's position?
I think their position is proper and righteous with regard to the estate.
Well, I don't mean that. I mean that's from an operational standpoint. If there's going to be less resource available to you, what does that mean to you as the person in charge of operating this system?
So I'd say that I don't have less, and remember, I've only been involved with the company for about 16 months. I have never been told no to something that I articulated as a safety requirement or an operational need. It has been supported, and we have done some really, really great things over the last 16 months since I've been on board. My feeling is that it's not affecting current operations. We can continue operations with what the Mitchells have done to this point. I don't have a crystal ball about what the Mitchells will plan to do moving forward based on the decision of this application. But what I can tell you, and maybe this is a little bit out of the scope of your question, is we all know as a workforce where the Mitchells stand on the future of the operation. And for all the reasons that have been articulated by Mr. Paul, which, like I said, are proper and righteous, the vision of the Mitchells as owners of this operation is to sell. It is very difficult to manage a workforce that is not able to unify under the vision of an owner. And particularly when the vision of an owner is to sell a company. So my challenge is to keep everyone focused on the job at hand. Sometimes it's difficult to do. But when you look at the opportunity and, you know, that Sharpview comes in and their vision is to invest and improve and expand. So when I look at this situation, I have a current owner whose vision for the company is to sell, and I have a potential owner whose vision of the company is to invest and improve. I foresee a lot greater opportunity to make the necessary changes and improvements in the system under Sharpview than I now currently foresee under the vision of the Mitchell family.
Okay. I have nothing further. Thank you again for being with us.
Commissioner Kimmerite? Oh, Commissioner McKissick?
Just one or two quick questions, and that's simply this. I've heard a lot about the advantages of electronic ticketing and moving to that system and how that may potentially impact ridership and and likewise on-time performance, but ridership continues to increase. So what are your thoughts as the person who's kind of in charge of these ferries?
The electronic ticketing is important for, in my opinion, the key aspect is flow. The entire performance, and particularly on-time performance of the system, is often predicated on ridership flow. When do large groups of people come to get on the island, and when do they try to leave the island? That's when we find our greatest challenge in trying to keep our schedule. And so the opportunity with electronic ticketing and hopefully a reservation system is that we level out the flow so that rather than 40% of our ridership trying to pack into 3 hours during the day, we can spread that ridership out during the day. We have shorter load times, less congestion within the terminal, and we can turn around the vessels quicker. The other thing is right now we sell every ticket at a window unless they're pre-purchased in bulk or through account. And so we minimize the amount of time or the number of lines that a passenger maybe have to wait in. There are definitely associated operational changes we'll have to make with regard to how we move people within the terminal to make sure that we maximize efficiency from the electronic ticketing system. But those are things that we're trying to work through now. So I think it's a must-have next step in the evolution of the system. And I've been working on it for a year and continue to work on it. It's extraordinarily complex. And one of the challenges, as was noted, is the unique nature of the ferry and tram system, which is nothing that anyone else in the country does the way we do it. Makes it difficult. Even the systems we're looking at support 22 other ferry systems and other rider programs, but none of them have a associated tram. And so the complexity of it is very difficult. But if we can get this right, if we can make it work, I think we can not only spread out the flow throughout the day and handle higher quantities of riders throughout the day, But we can also provide the customer a much better experience, both from a interaction standpoint with our business and then from their experience on the vessels and the trams themselves.
And when do you reasonably anticipate electronic ticketing system will become operational?
Our hope is this year.
Okay. And I take it from your testimony that you anticipate that this will improve the ability of the ferry system to make one-time departures.
I think it's one component to help us get there. If we have fog, if we have a dredge, if we have sometimes even a minor equipment casualty. One day we had smoke coming out of the stack and we had to stop the boat, and we ended up sitting there for about 10 or 15 minutes because of the lack of elasticity in our schedule. We never made up that day. So because of one small incident, that entire day was outside of our on-time performance parameters. We may have been running on time by interval in between there, but in terms of our schedule, we weren't there because of just one incident. And like I said, because of the lack of elasticity in the schedule, we have no ability to make up that time throughout the day.
Thank you. Appreciate your testimony. I think you helped put things in an appropriate context.
Okay, questions on commission questions? Ms. Hawkins?
Thank you. Good afternoon, Captain Stewart. Or good morning, afternoon. You were discussing with Chair Mitchell some of the differences between Bald Head's budget as compared to the New York City and Washington Ferry's budgets. And let me just ask kind of a context question here. The Bald Head Ferry is just one route, is that correct?
That is correct.
From D Point Terminal to the island, right?
Yes.
Are you aware that the state of Washington Ferry operates 7 different routes?
Yes.
And that many of those routes are operated internationally, even to Canada?
Yes.
And are you aware that many of those routes have more than 2 ports?
Yes.
That one has 6 ports?
Yes.
Are you aware that the New York City ferry operates 5 different routes?
Yes.
And that almost all of those routes stop at more than 2 ports?
Yes.
And you were talking a bit about the Mitchell's investment, and you said that the Mitchells have never said no to any investment for safety and operations.
Correct.
And I think you said that they had done great things.
If you look at the status of this particular system, what it does and it's able to do and what they've done over the last 30 plus years, they have done some great things.
Mm-hmm. Yeah. Tell me more about the great things they've done for safety and operations.
You may not know, but I was the officer in charge of marine inspection in Sector North Carolina for the Coast Guard. We had responsibility for inspecting untold number of boats throughout the entire state of North Carolina. There is no question that the best maintained, safest operated vessels historically, and by my experience and by my inspector's experience, was with the Bald Head Island ferry system.
And do you believe, you've been in this position since October 2021, is that correct?
Correct.
So year and a half-ish.
Yes.
Do you believe you've maintained that standard as the best maintained ferry fleet?
Absolutely. And I've gotten personal comments from the inspectors. In fact, I have a vessel out of the water right now going through dry dock, and everything we've done on that boat, I get very positive comments about how well we run our maintenance systems, how well we operate our vessels from the inspectors. And you know, the reputation, I'm not owning that reputation. I'm just carrying forward a reputation that was already built.
I understand. And you talked a little bit about the development and implementation of the electronic ticketing system. I think you testified that in your direct testimony that you're overseeing that process.
I am.
And that's been paid for under current management by BHIT, is that correct?
Correct.
And I believe you testified that Sharpie's vision is to invest and improve and expand. Is that correct? I think he said that just
Well,
earlier.
I think if you look at the plan for vessel replacements and things like that, that's how I would couch expand. But in terms of adding additional capacity, I don't know if we specifically discussed that, but I think it would be a prudent part of a longer term discussion
And-
as we look at rider numbers.
And when you say the plan for vessel improvement or replacement, or I can't recall which word you said, what is that plan?
I believe it's been presented in some of the closed sessions. We haven't, there have been notional discussions in the broader sense. There has been, as has been indicated in testimony, the establishment of a firm plan is really something that needs to happen once the transfer takes place. And Sharp View has the opportunity to work directly with myself, Mr. Paul, and Ms. Mayfield on what the specifics of that plan look like, what the timing of that plan looks like, all correlated with other factors regarding ridership and everything else. I think in my opinion, and I've taken command of a few units, I never walk into a new command with a plan in place. I need to evaluate and understand the current circumstances. Throwing spaghetti on the wall of a bunch of different things and seeing what sticks is inefficient and ineffective. It provides no direction to the workforce. And it often is incredibly disruptive to the flow of the workforce. So I think that Sharpview's plan and what they've articulated to engage with us on longer term investment strategies for the maintenance and sustainment of the system are absolutely correct.
So just so I'm understanding, the plan is for after the transaction closes to evaluate things. Is that what you're saying?
I think to the initial evaluation, there's discussions, but to establish a firm plan that can be actioned upon, that will take a little bit of time because you want to make it right. It's got to be achievable. It's got to be reasonable. It's got to take into consideration all the variables that you cannot necessarily understand or know until you've had that in-depth exposure being on the ground.
Understood. And do you understand that one of the questions before the commission in approving this transaction is whether or not there's a benefit to the public?
Yes.
And did you hear the public staff testimony this morning that a 90% on-time performance standard would be a benefit to the public as part of this transaction?
That may have been discussed separately. I know it was referenced as one of the items that were adopted, but whether they deemed it a direct benefit, I didn't hear that specifically.
Okay. And I understand from your testimony just now that you don't think a 9% on-time performance standard is a realistic standard.
No, I think it's a realistic goal.
But your
It's
priority is
something-
safety over.
But I
on-time
will
safety.
not exchange that goal for the safety of our passengers or crews or our vessels.
So are you unwilling to commit to the 90% on-time performance standard?
I am willing to commit to try and, as that is a goal. What I am not willing to commit to is that I will cut any corners to achieve that goal.
And I think I remember from BHIT's discovery responses that the handbook for the ferry currently sets a 90% on-time performance goal. Is that correct?
Yes.
And since you've taken over at Bald Head Island Transportation, you've not met that 90% standard. Is that correct?
Not in an overall year. Some months we do, some months we. In fact, in February, we reached 89%.
Okay, but not 90.
No.
Okay, nothing further.
Very briefly. Mr. Stewart, on the question of the plan, if Sharpview were to complete the transaction, are you aware that there's a condition that's been proposed that within 1 year of the closing of the transfer, Holdings and BHIFT will file a 10-year plan for capital expenditures to replace any of the current ferries?
I am.
And then you were asked a lot of questions by Chairman Mitchell about the budget per rider. Do you remember those
Yes.
questions? You talked a little bit about, in your answers, about the important role that money plays into safe and reliable services. My question to you is, do you expect that your ability to operate safely and reliably will be impacted at all if Sharpview were to acquire the assets?
Absolutely not.
Why not?
Well, I think the the engagement with Sharpview, the commitments they've made, they have indicated to me, both in document and in conversation, that they are willing, able, and supportive of making those investments. And I think what was key is they're willing, able to make those investments based on my recommendations and requests, which is important to me in terms of an ownership, understanding where the expertise lies.
Nothing further. Thank you.
Captain Stewart, we appreciate you coming here today and testifying. You're excused.
Thanks.
Okay, so it is almost 1 o'clock. We're going to recess for lunch. We'll plan to be back on at 1:30. And hopefully we will finish up this afternoon.
Ready? Okay.
Yes, you may proceed.
Thank you. I'd like to call rebuttal witness Lee Roberts and Charles A. Paul to the stand. Gentlemen, could you please state your name and position of employment for the record?
I'm Lee Roberts. I'm managing partner of Sharpview Capital in Raleigh. I'm Charles Paul, CEO of Baldwin Island Limited and president of Baldwin Island Transportation.
Have you caused to be pre-filed in this docket rebuttal testimony consisting of 37 pages, 2 addendums?
Yes. Yes.
Was this testimony prepared by you or under your direction?
Yes. Yes.
If you were asked these same questions today, now that you're under oath, would you provide the same answers as in your pre-filed testimony?
Yes. Yes.
Do you have any corrections or additions to make to this rebuttal testimony?
No. No.
Were there 8 exhibits identified and filed concurrently with this rebuttal testimony?
Yes. Yes.
Are those exhibits true and accurate in representing what they purport to represent to the best of your knowledge?
Yes. Yes, they do.
Have you also prepared a summary of your pre-filed testimony that has been filed in this docket?
Yes. Yes.
At this time, I'd like to move the rebuttal testimony of Lee Roberts and Charles Paul, plus the 2 addendums and the 8 exhibits into evidence as well as the summary.
Okay, the confidential pre-filed joint rebuttal testimony of Charles A. Paul and Lee H. Roberts will be received into evidence and treated as if given orally from the witness stand, as well as the 2 addendum and the 8 exhibits will be identified as marked pre-filed at this time, and then the summary will be received into the evidence at this time.
And the only other note I would make is that Exhibit 6 and Exhibit 7 are confidential attorney's eyes only exhibits.
And Exhibit 6 and Exhibit 7 will be treated as confidential attorney eyes only.
Thank you. The witnesses are available for cross-examination.
Good afternoon, gentlemen. Marcus Tratham for the Village, Baldhead Island. Chair Duffley, I have just one kind of ministerial matter. I've had a conference with Council for Limited Transportation about designating a couple of exhibits which will help streamline the cross-examination. They're essentially two exhibits. They're from the last proceeding. It's financial statements of Baldhead Island Limited Parking from 2016 through 2021. These are the audited financial statements. And then the comparable statements for the barge department. And these were previously marked as confidential, but I understand from council that this falls within the rubric of historic financial information and could be filed as non-confidential.
They can be filed as non-confidential, and we'd have no objection to they being admitted in the record by stipulation.
And are we marking them?
I don't see a need to. If I could get them in the record, I don't need to ask questions about them.
Okay, thank you, Mr. Tratham.
Thank you for that.
Gentlemen,
So we are going to just go ahead and admit those 2 documents into the record now.
Thank you. And I do have some copies if anybody wishes to have copies available. Gentlemen, with respect to your rebuttal testimony, pages 16 through 24, you've got an extended legal discussion about acquisition premium. Can I assume that neither of you is offering legal opinions on these issues?
No, I'm not offering a legal opinion on the term acquisition premium. We don't believe there is an acquisition premium in the sense that we understand the term as corporate finance professionals.
Okay. And you're aware that there's typically legal briefing after the evidentiary hearing, correct?
That's my understanding, yes.
And it wouldn't surprise you if the village made its legal arguments in its post-filing brief, would it?
I suppose not.
Okay, so I'm not going to ask you any questions about those matters. Mr. Roberts, we had a discussion, I don't remember how many days it was, a couple of days ago, with regards to performance fees, and you had kindly agreed to run a calculation for us, and I understand that you have done that now. I don't know whether or not this has been passed out. I've got a copy of it. Mr. Farrell, has this been passed out generally?
It has not. We provided it to council this morning after we received it early this morning. And so it wasn't clear to me whether or not that was going to be offered by anyone as an exhibit. We have copies if folks would like them, or if you would like to use it as an exhibit, we have copies.
Okay, why don't we just go ahead and pass that out? I've just got a couple of quick questions on that document.
Yeah, I'm just looking. Marcus' exhibit, okay. Hey, Zeke, I need 3 back.
We
And we need them up here. Thanks. I need one. Yes. I think I got 30.
Thank you very much.
So if we could mark this as Village Roberts Paul rebuttal number 1.
It shall be so marked.
And this is labeled confidential, attorney's eyes only.
It will be designated as such. Do we need to clear the room? Are we going into confidential session?
I believe we are.
Yes, but I think everyone in the room has probably signed it.
Okay, Mr.
Agreed.
McCoy. Thank you.
Mr. Roberts,
doing? Okay. So now we're back out of confidential session. We'll go back to Mr. Tratham.
Yes, Mr. Roberts, just want to touch on an issue that is certainly of concern to the village. Will not be a surprise to you. I believe you understand that the village wishes to be clear that the commission has the unfettered ability to regulate the consolidated transportation structure. You know that's a desire of the village, right?
When you say the consolidated transportation structure, you mean?
Parking, barge, ferry.
Yes, absolutely.
Okay. And you understand that the appeal that Sharpview is party to challenges and threatens that prospect, don't you?
I do.
Okay. And in this room, in this hearing, you've invoked the commission's regulatory oversight as a reason for assurance that the public will be protected, haven't you?
I have, yes.
So I'm just curious, how do you square the position in the room with the appeal you've taken to challenge the commission's determination of its oversight authority?
Well, so you looked at our investor presentations in, I think it's fair to say, painstaking detail, and even prepared a summary of them. So you've looked at them closely enough to know that what we forecast for the parking, to take an example, was an increase of rates of 50 cents every other year. That's what we forecast long before the sub 21 ruling. That's what we continue to forecast. That's obviously well within inflation. And so you don't have to take my word for the fact that we don't have a plan to raise parking rates faster than inflation. It's consistently what we've presented to investors and what we've underwritten. So in our view, it's not necessary. The regulation itself imposes its own cost, which is then borne by the ratepayers, and it obviously creates a lack of flexibility. So in our view, the regulation of the parking, I'd say the same thing about the barge, imposes a cost without a countervailing benefit.
Reflecting on Mr. Taylor's testimony, and understanding that the current approved rate of return is 8.33%, will your investors be satisfied with 8.33%?
Yeah, that's a WACC. So that includes both the debt and the equity.
It does.
So that's not the return to our investors.
Okay, but it's the return on the investment. Are your investors satisfied with 8.33%? Can you make a business case based on that?
Again, my investors are the equity investors. So they're the 40% of the that goes into the WACC calculation. So, but yes, the answer to your broader question is the returns implied by the 8.33% WACC are attractive to our investors.
Okay. And just be clear, obviously there's disagreement about how the rate making rules apply in this context, but from your perspective, you're not asking for any special rate making treatment or rules with respect to this investment, correct?
That's a legal question to some degree. I mean, to the extent that the witness can answer factually, but I mean, to the extent that you're asking them about alternative rate making processes or what their rights may be under the statutes, that goes into issues of law, which would be the province of council.
Sure, I'm fine to answer to the extent you can.
I'm not sure I understand what you're asking. I'm sorry.
To your knowledge, are you asking for any special rate making approach or treatment? Or are you satisfied with the commission's existing rules and processes with respect to setting rates?
I have to say, this is my first, this transaction is my first interaction with the North Carolina Utilities Commission as an applicant. And so I don't believe that we're asking for anything unusual, but I'm not sure I have the experience to answer that conclusively.
Sure, that's a fair response. That's all I have. Thank you.
Mr. Higgins.
Thank you. Excuse me, Mr. Roberts. At the time Sharpview entered into its asset purchase agreement with Bald Head Island Limited for the assets that we've spent the week talking about, Sharpview knew that commission regulation of the parking and barge assets was in fact a possibility. Correct?
Absolutely.
And did Sharpview's due diligence include an analysis under a scenario where the commission subjected the parking and barge assets to regulation?
Well, I think I'd give the same answer. So because our underwriting assumed that the rates for parking and barge would increase significantly inside the rate of inflation, we didn't think that the prospect of regulation would affect our underwriting, our economic case for the transaction. I don't know if that answers your question.
I'm sorry to say, I don't think it does.
Well, so when we thought about the prospect of parking and barge being regulated, what we thought was if parking and barge become regulated, our understanding of the commission's process and guidance is that rates may still increase at the rate of inflation. And because our assumptions were that even in an unregulated environment, our rates would increase significantly less than inflation, that our underwriting case, our assumptions of what the economic returns of the parking and barge business could do would not be affected. At the same time, there is the cost of the regulation itself and the lack of flexibility.
You heard Mr. Taylor's testimony earlier today about his analysis with regard to the parking and barge operations if it was included. And this is a
Presiding Commissioner Duffy, I think that might have been part of a confidential testimony.
So at the record, because
Maybe just strike that number and refer to it generally.
We will strike that number.
Thank you.
We'll, work on the video as well.
I should be put in timeout.
You're riding outside on the ferry on the way home, Mr. Higgins.
On the front.
On the front. And it'll be the Patriots, so you get really wet, okay?
Did Sharpview determine whether, subject to your point about raising your projections that you're never going to raise rates? I'm not trying to pin you on that you don't anticipate raising rates outside of the rate of inflation. Did Sharpview determine or project in its underwriting analysis that it could fulfill its or honor its projections to its investors with or under the existing ferry, barge, and parking rates?
Without ever increasing for inflation?
No, with
Yes.
baking that into the equation.
Yes. So I was asked by Senator McKissick in the sub 21 hearing whether we would go ahead and close on the parking and barge assets, even if the commission did decide to regulate them in the sub 21 hearing. And what I said was that I believe that we were contractually obligated to do so under the APA, and that I said that because it's true, and that's that's continued to be our intent. So we believe it's preferable if they're not regulated for the reasons that I've stated, but we've been prepared all along to move forward with those assets being regulated.
All right, sir. Thank you for that. Mr. Paul, a question for you. When was the Deep Point Ferry Terminal put actually into service?
In the summer of 2009.
Okay. Would you agree that since then, since it was put into service, that the parking lots at the Deep Point Ferry Terminal have been used by the ferry riding public to park their vehicles?
The ferry riding public, in addition to other people from the public, have parked in that parking lot, yes.
Yeah, so those people who decide to come and have lunch at the ferry terminal.
And folks that are using the residential marina and folks that are visiting the shipping and receiving facility.
All right, sir. I don't have any other questions, gentlemen.
Mr. Creech?
Good question. We've talked about closing in confidential session, but this wouldn't be confidential, but when do you anticipate at this stage when closing will actually occur? You've got the ROFR, you've got your appeal, you've got the commission's order, of course. What is your timeline now?
So our closing timeline does not depend on the appeal of sub 21, as I tried to make clear. Were it not for the ROFR litigation, our plan would be to close as assuming were the commission to approve our application, our plan would be to close as rapidly as possible after that approval. There's nothing else we need to do from our end to proceed to closing, and we've been in that posture now for many months. So we would like to close as rapidly as possible. But I said, leaving the ROFR litigation aside, and we're not a party to that litigation. We're obviously curious about how it turns out, but I'm not sure I can give you a forecast.
We are moving forward with the assets that are part of the asset purchase agreement that are not part of this hearing. We are moving forward to close those assets by the end of the month.
So what you're contemplating is a two-step closing then?
We're going to have at least a two-step closing.
Yes, I'm sorry, I should have, there are these supplemental assets that I've mentioned before that we plan to close on imminently.
All right, and what you're saying is, without going into purchase price or anything like that, what you're saying is obviously, understandably, any transaction that a portion is allocated to the issues before us today, and a portion is allocated to these other assets that are not regulated or might be applicable. The universe of non-regulated assets, whatever that universe may be, you're going to close on those here coming up.
Yes, sir.
Yes.
And would you amend your APA to provide for that, or do you think your APA already provides for that, et cetera?
The APA allows for that. Notwithstanding, we will have, we've already circulated closing conditions for those supplemental assets to make sure that we don't have any misunderstanding. So for example, there could be a claim that portion of those supplemental assets might be involved with a ROFR, and we have mitigated that. SharpView is going to close on those assets all cash. The reason why they're wanting to do that is if you look at the broader APA, there's no financing requirement there. Cash. The Mitchell's estate has not got a financing condition. So if their lender goes poof, well, then we're going to be an all cash purchase. And so because of that, SharpView is going to close all cash on the assets that are not part of this hearing. And the estate will manage whatever ROFR cloud to title. They'll be effectively the title insurer on that specific issue.
I just want to be completely clear that those assets are none of the assets that we've discussed this week here are included. We're talking about real estate on both the island and on the mainland, the marinas, and some, we call them the supplemental assets for a reason. They're aside from the transportation infrastructure that we've been discussing. I would note though, that's close to a $12 million purchase. That's a significant investment in the island and what I've been calling its ecosystem, apart from this transportation system purchase. That's about the village's annual budget being invested in one ancillary transaction.
And don't answer this if you think it's a confidential question, but will any of those assets be pledged as part of the known loan transaction?
Well, we're closing all cash, as Mr. Paul indicated. I do think the answer to that is probably confidential. Uh, I would refer you to the term sheet.
We have it in the record, in
Yes.
the term sheet.
That's in the record.
Thank you.
Ms. Farrell?
Mr. Roberts, you testified that the regulation of parking in bars did not impact your or the investor's decision to make this deal move forward, correct?
That's right.
And that's also correct testimony as it relates to the lender and their willingness to fund this deal and loan money on this deal, correct?
I'm not sure they said that no matter what happens, we're there to fund, but upon receiving and reading the sub 21 ruling, they did confirm their willingness to continue to proceed with the transaction.
No further questions.
Okay. Commissioner questions? Commissioner Brumland?
Yes, Mr. Paul, a minute ago, in answering a question, you discussed the sub 21 order and said that it didn't, your reading of it is it didn't require any type of rate setting and could even continue with imputation from the parking or the barge or whatever you recall that.
Yes, ma'am.
Would it provide any benefit from a business perspective, and either one of you can answer, but would it provide any benefit if the commission's order were to state exactly that?
I think that it would benefit everybody if we had a clear understanding how the assets would be operated from a regulatory perspective. So if that's one way the commission wanted to go, it would provide clarity. I think that my answer to that prior question was that the village has proposed throughout this hearing that order is that you will fully regulate from a rate perspective all of the assets from a full-on perspective using a rate-based methodology. I did not read sub 21 to say that that was the absolute answer. I read it was that you were going to evaluate it. You were going to provide whatever flexibility you wanted to do for yourselves as well as the operator. But it would provide clarity. Absolutely. Yes, ma'am.
Or even if it stated something like regulatory, it's something as simple as securing the right to parking and barge services for the ferry.
That would be fine. Again, I think that the key to it is what Mr. Taylor pointed out today. There was a lot of submittals in sub 21 and a lot of submittals here. We pulled, I think, 13,000 emails to try to find something about a rate problem or people complaining rates. We don't have people complaining about rates for parking and barge. That's not an issue in terms of what we're charging for a service. So to the extent that we need to talk about that in sub 21 or in this here, that you would say, hey, that you might look to that, that would be a great way to provide some clarity. In terms of Mr. Roberts signing up, remember, even though it's his stipulations, whatever he agrees to, you all are going to pretty much look to us if we're still owning it. And we would be fine with committing to providing the same number of parking spaces available and grow those rates at inflation, and with the barge, grow the barge rates at inflation. If that became the order, we can live with that. I'm confident Sharpview can live with that because that's how they modeled it. And they modeled it just like it was coming out of the authority and just like Standard & Poor's did.
Thank you.
Chair Mitchell?
Gentlemen, a couple of questions for you all. I think y'all were both in the room. Mr. Paul, I think you were for sure. Mr. Roberts, if you may not have been. When I asked Mr. Gardner some questions about the dialogue between the village and Transportation Unlimited. And so I want to ask y'all those questions. And in general, I want to understand how much conversation has happened between the parties. I'm clear on how much litigation has happened. But how much conversation has happened? How much have you all heard from the village about specific service quality concerns that the village or customers may have that you could address? So help me understand just respond to the question and I'll ask follow-ups if necessary.
Yes, thank you. So I wrote down what you said in that line of questioning because I liked it a lot. It was consultation and cooperation can go farther than litigation, and we agree. So the day we announced the transaction, I traveled to the island to meet with the mayor and introduce myself, explain who we were and what we were trying to do. And we reached out to the village several times. You've heard testimony about the meetings that we've had with them. They unilaterally stopped those discussions. But the village is only a subset of I've been using the term ecosystem. So 275 full-time residents voted in their bond referendum. That's not the ecosystem. That's not this business. That's less than 2 ferry loads. They could all ride the ferry every day, and that wouldn't be a business. The island and the ecosystem it's the homeowners, and then it's obviously the renters and the contractors and the employees and the day trippers. But the homeowners are represented by the association, and that's the 1,350 homeowners. We've had excellent dialogue with them. We've presented to them formally twice. I'm afraid you weren't here, Commissioner, in the sub 21 hearing, but the head of the Bald Head Association talked about our cooperation and the dialogue that we have had underway, and that's been very productive and constructive. And that's just been the formal dialogue. There's really not certainly a week, but maybe not a day that goes by when I don't get a call or an email or a text from somebody with an interest on the island, generally a homeowner, sometimes a frequent vacationer with suggestions and dialogue. And some of it's more constructive than others. Sometimes it's, my dog got seasick on the ferry, or a baggage handler wrinkled my outfit. But a lot of it is constructive and thoughtful and helpful to us as we try and learn more about the system and the infrastructure. So we feel as though the dialogue with the island writ large has been very positive and very constructive, and we would hope that the dialogue with the village, that narrow subset of full-time residents, can be restarted, and that we can work with them cooperatively and move forward together as partners.
All right, Mr. Roberts, I appreciate that. That is very helpful to my understanding, and appreciate your filling in some of those gaps in my understanding. Some of the things I heard Mr. Gardner testify to seemed very pragmatic and simple things that could be addressed or planned for at some point down the road. So I do hope at some point that the relationships are mended enough between all of the parties in this room to have civil conversation again. Because I think everybody would benefit.
By all means.
And Ms. Mitchell, we have a very open and collaborative discussion daily with Chris McCall and the staff. There is not an open war out there politically nor operationally.
And those are village staff, just
village staff. Chris McCall is the town manager, and I am probably talking to Chris 2 or 3 times a week, and he's talking to Bayonne Stewart about whatever we need to do. Most of the issues that have been raised about on-time performance were primarily due to COVID. That's people's most recent expectation. And to put that into perspective, it's not just the village that I have to work with. The majority of these assets lie within the city of Southport. And I would suggest to you, the mayor of Southport, and his view of how we're going to operate under COVID in his jurisdiction was very different than what the mayor of Bald Head was going to do in his jurisdiction. And then we had the governor was going to say one thing. So balancing those out, we balance those things out every day. Did we get it all right on COVID? No, but but I would suggest we did the best we could. And the delays and the baggage with people bringing supplies for months, that all impacted. That's everybody's most recent expectation and memory. But if we have complaints daily, if I get a call at all from the commission staff, if Mr. Rajiv calls me, I get right on it. He emails me the issue that someone brought up, and we're on it. And the same thing with the village. When they get a complaint, they just push it on to me. And we try to resolve those.
All right. Well, thank you, Mr. Paul.
So Chair Mitchell jumped ahead of me. I mean, have the same line of questioning as I was going to do, but I did want to reiterate, you heard my line of questioning with Mr. Gardner.
Yes.
And he is sincere. He wants to work with you. But I heard you say the village unilaterally stopped meetings. I think Mr. Gardner's testimony is that the two of you are not meeting with him. So obviously, the truth probably lies somewhere in the middle, and I would really encourage the two of you, it sounds like both groups, all three groups, do want to open up conversation again, and I highly encourage it as well as Chair Mitchell did.
Yes.
Commissioner Claufelter.
Okay, this may take a little time. Let me say a couple of things by way of preliminary. First, I haven't thought about exactly how to ask the question before. So that's why it's going to take a little time. So to set the question up, I may need to say a few things to you so you understand the context of why I'm asking what I'm asking and what I would really want to know.
Sure.
First point. Second point is an obvious one. I think this commission has regulatory jurisdiction over the ferry and tram operations, and that's not even in dispute. In the sub 21 order, we were trying to wrestle with the question of how does that jurisdiction play when the assets over which we have jurisdiction are so intertwined with other assets over which, whether or not they're subject to the statute is a matter of statutory law. It's not a matter for us to say or not. It's a matter of what the statute says. But we haven't exercised whatever jurisdiction might have existed or might not have existed. We just haven't played it. That's what we're wrestling with. And we were wrestling with that in the 21 order. I consider this proceeding to be a second stage in trying to deal with that question. They're not separate in my mind. They're two stages of trying to answer a very complex question. So speaking only for myself as a commissioner, I would see great benefit not only to the commission or to the parties, but to the public in general if we can use this second stage of addressing the question to try to resolve it all. Boy, that would be a great outcome, I think, for everyone. So I'm going to sort of say those two things preliminary. One, it's going to take me a while to set up the question. And second, I think you see what my ultimate objective is to try to see if there is a way that we can address that fundamental question. How does the regulated asset relate to the other assets, whether they are regulated under the statute or not? How do they fit together? So let me back up. I try to put myself and think about that in the perspective of not the village, not the perspective of Bald Head Association, or the club, or the Conservancy, or the Mitchell family, or Sharpview, or the town of Southport, or any of those constituencies. Try to think what matters to me as a member of the using public who uses that transportation complex. And that to me defines the public interest. That's what defines the public interest. And my job as a commissioner, I think, is to give the public interest priority. So I try to think, well, as a member of the public, what do I care most about? And that's what I think as a commissioner, I need to care most about. Well, I care about price. Okay, I care about price, and we've spent a lot of time talking about price. Charges, fares, tariffs, regulated rates, non-regulated rates, increases at the rate of inflation, this, that, and the other, all of that. I want to leave all of that to one side because there's something I care about even more than that. And that is that I have a seamless experience. When I go down to Bald Head Island, I park my car, I come up to the window, I buy my ticket at the terminal. I may have lunch at the terminal. I may not. I may have eaten on the way, but I may have lunch at the terminal. I wait around. I get on the ferry. I go over there. I know my bags are going to get across, and maybe I live there. Maybe I don't. Maybe I'm renting, but maybe I'm bringing something too big for the ferry and it's got to go over on the barge. I know it's going to get there, that they're all going to get there about the same time. They're going to be protected, taken care of. When I get there, I'm going to have a great time on the island. And then when I go back home, I have the same seamless experience. That really is what I think the fundamental public interest is all about. So what are the things that could threaten the public interest? Well, again, I want to say, cost is an important one, but there are all sorts of ways to address cost. You guys have put all kinds of things in the regulatory conditions and to talk about costs for parking and all of that sort of stuff. And we've got jurisdiction over the ferry rates, and you're not going to get out of line on the barge rates, I trust, because it's going to blow the whole system up if you do. There are elements there, other ways to deal with cost issues. We've got control of some of them, and we can help influence some of the others, and you give an undertaking. So let me put cost to one side again. Rates and charges to one side. How do I protect against the real risk? And that is that the seamless experience blows up. That's all about whether the assets are under common ownership, management, and control, and they have been. They have been under the Mitchell family. That's just the history. Well, I'm not really hung up on who owns those assets. Again, I'm a consumer. I don't really care as a consumer who owns them. I don't care whether it's the Mitchell family. I don't care whether it's the Village of Bald Head. I don't care whether it's the authority. I don't care whether it's an investment firm or a group of investors. The ownership is not what matters to me. It's the integrity of the group of assets as a combined operation. And so I'm thinking from the public interest and my attention to the public interest as a commissioner, what matters to me most is the assurance that those pieces of that seamless experience not get fractured and broken up in a way to where now I have to deal with one group of employees from one company here, one group of employees from that company there, different operating policies, different operating practices, who are not talking to each other, working to each other, and working as a single team. That to me is the most important single regulatory condition in this case. And it might actually help answer the question of what kind of regulation was the commission really struggling for in the sub 21 docket. That's the setup for the question. Got it?
I think
Yes,
so.
sir.
So suppose the regulatory conditions in this case didn't say anything about beyond what you guys have already proposed about leases and rates and increases and cost of living and all of that sort of stuff. And when you come in for general rate cases, suppose it said whatever you guys have proposed, but suppose it said fundamentally that the package won't be disbanded and split up under different owners, unaffiliated, unrelated, unintegrated, operationally integrated owners without the commission having a chance to blow the whistle. What would you say?
So I think Mr. Paul should answer as well, but I think would be receptive to something like that. It is operated well for a long time, as you say, because of the common ownership. And I gave the example in the sub 21 hearing I used the example of Carowinds that there are some differences, but when nobody has to go to Carowinds. And when you go there, you have to park in their parking lots and you have to buy their food. But if you don't like the experience or if it costs too much, you just won't go. And that's true for most of the users of this system. There's this small group of permanent residents who don't have, their demand's pretty inelastic. But for most of the users, certainly all the marginal users of the system, all the demand comes from, the marginal demand comes from users whose demand is pretty elastic. It's certainly true if you're a day tripper. It's certainly true if you're a renter on the island. You'll go rent a house somewhere else for the summer if you don't have a good experience, and maybe you won't buy there if it's too much of a hassle. It's already a little bit more of a hassle than going to any other beach, but you do it because it's worth it. And so that's how we think about it, is that it needs to be attractive to people who have other choices, not just the full-time residents who have relatively limited choice. It needs to be an attractive destination. And the experience of parking your car and getting there and pulling up with 3 kids and a dog and your coolers for the week has to flow pretty well. And so we completely understand that, and we're receptive to any dialogue that the commissioner or the public staff wants to have about how to address that. I don't know if that fully answers your question or not.
It's as far as I think we ought to take it today, but again, I think I've made the observations I wanted to make, which is that, again, what we were grappling with in 21, what I was grappling with, speaking again only for myself, I shouldn't say we, what I was grappling with in 21 was, what does this commission need to do to preserve the integrity of that unified operating experience?
Yes.
And it may or may not require, as the commission said in the 21 order, it may not require the full panoply of what we do with Duke Energy.
Right.
But it fundamentally, and maybe most importantly of all, maybe it's the only thing that matters, it's the most important thing that matters to me, is the integrity of the combined operation. If there's a way to address that in the regulatory conditions, that may make a lot of the other issues easier to settle among the parties.
I understand.
That's
So Mr. Claude
I'm done.
I would say that that's what we've been trying to do with public staff and the commission since we first sat here in 2016, was to create an opportunity where the status quo could continue to exist. And the Mitchells were gracious enough to try to make it a status quo opportunity. And we have found a status quo owner that has made commitments to you all to try to keep that as seamless as possible.
I like what you say. Now the lawyer in me says, go back and tinker a little bit with those commitments.
Yes,
okay?
sir. I would, on all of those commitments, including the
Gotcha.
5.4 million.
How they're written down and how they're expressed. So go back
Yes.
and do some tinkering. Thank you. That's all.
So I had written down the question in a bit different way, but I think it could also help with the task that you're being asked to do. So I think when you're looking at the regulatory conditions, write the conditions or look at the conditions, assuming that the Court of Appeals reverses that December 2022 order in sub 21. Assume that order does not exist and look at the conditions to protect against this, what Commissioner Clodfelter so eloquently stated about seamlessness of the experience of but also keep in mind the employees as well.
Yes.
And thinking about the employees, they're a little bit more inelastic. And it have to be there to
Indeed.
support the island. So thinking about the employees and that issue, figuring out what type of conditions that you can agree to that really addresses Mr. Gardner's concerns.
Very good. Thank you.
Are there other questions? Commissioner McKissick.
And I guess I'll start on these regulatory conditions as I was about an hour ago. In any case, based upon the regulatory conditions that have been proposed by public staff at this time, and I've looked at it and compared and contrasted those to the ones that Sharpview has outlined and it's attached to your rebuttal testimony, are there any conditions that public staff has recommended that you consider to be seriously problematic, and why?
I don't think so. There might be wording that we're still iterating, but in general, I think there's been broad agreement between us and the public staff.
That's encouraging. And of course, kind of chiming in on this note of trying to come up with things that might be, provide some creativity that might answer some of the questions that are before us at this time. I would likewise encourage you and the public staff to give thought to what further regulatory conditions might be included that would address some of these concerns. And I know you pointed out the difference between the village, and I believe you said the 254 odd people that are there versus the association. I take it your relationship with the association has been pretty good historically?
I'd characterize it as excellent. Yes, it's been a robust and positive and constructive dialogue.
And as I recall, I actually saw a testimony from someone on behalf of the association that was in support of this transaction. Is my recollection serving me well?
They filed the testimony. Maybe Mr. Paul can explain exactly what happened. I think what happened is they filed the testimony and then they had a new leadership and then couldn't agree. I think then they split 3-3 and decided to
become neutral.
I think, is that an accurate?
Yes, sir. That's what happened.
All right. And let me ask you this, as it presently stands, I mean, obviously working together collaboratively, cooperatively, the association, the village, the Sharpview group can obviously be in the mutual benefit of all of the parties. I mean, in terms of resuming discussions and conversations to address issues, do you see an opportunity to do that? Because I think that commissioners here would certainly like to see that improve or see that dialogue.
Absolutely,
further.
Mr. McKissick. So let me reiterate. Operationally, we do not have any issues talking with the village. Those channels are absolutely wide open. Where we have conflict with the village is their intervention here and with a ROFR to prevent the sale of the system. As it relates to talking about improving on-time performance or adding some shading, or you maybe converting the Chandler building to an on-island terminal, those conversations are fluid and active every day of the week. Where we have issues is that we have a competing bidder who wants to upset this transaction. On the operational side and improvement side, we have not closed those doors, and we're interacting with the village and the island constituency on a daily basis.
And I believe you indicated you and the town manager have almost daily.
Chris McCall has daily interaction with our organization daily. And I would say that I talk to Chris somewhere between 1 and 3 times a week, and Mr. Stewart's talking directly to Chris 1 to 3 times a week.
And in terms of members of the association, approximately how many are there based upon the number of homeowners there?
I believe it's about 1,500 members of the association. There's 1,800 properties, but I could be wrong a little bit there, Mr. McKissick.
And have they had significant dialogue with you in the past? I mean,
Yes, we've had significant dialogue with the association. To include, Mr. Roberts and I appeared before the association at 2 town hall meetings that they held to talk about the transaction and to talk about issues that they may have relative to the ferry and the operations. And we've committed in those stipulations that we would continue to have a formal meeting on the island and a formal meeting off the island once a year to talk about operations and update them on a formal basis, not just through the village or not just through the association.
And I know most associations have some type of a newsletter for communicating with their members. This, assuming this transaction were to go through, would you, when I say you, the Sharp View entities, have your own newsletter trying to communicate with?
We communicate through the association has a very robust newsletter. Every single filing in this docket and in 21 is presented on there. And all the links to our websites are on there. But what I would anticipate is in the stipulation when we say we're going to have 2 meetings a year, that we would do that through them, not just ourselves, for public notice periods. But we routinely post things on the village website and on the association website when it comes to things about the ferry.
Excellent. Well, I think the more of that interaction can occur, the better. And if the association is willing to serve as a conduit for that communication moving forward, I think that would be an excellent way to proceed. And I think we have a lot to deliberate over. Been a lot of testimony this past week. Thank you.
Commissioner Kimmerite?
And I want to follow up for all of the parties on what Commissioner Clodfelter had stated. Following up on that, I want everyone, all the parties and everyone in the room to not forget that and to stay focused on that we still have two heavily litigated issues that have not been resolved. The first one is, among other issues, but one is whether the rate base is going to be established in this proceeding. And then the second one is what the rate base will be. So following up on what Commissioner Clodfelter said, let's stay focused as well on those two unresolved issues.
Okay, questions on commission questions?
One quick question, if I may. Following up on Commissioner Brown-Bland's question related to sub 21 and various comments there, regardless of this two-step closing, that first closing would not prevent or impact, given effect to the regulatory conditions that are being discussed. Is that correct?
That's correct.
All right, no other questions.
Yes, Mr. Roberts, with respect to some questions about your dialogue with the village, you've never asked for a meeting with Mayor Quinn, and he's refused to meet with you, has he?
Well, as you know, Mr. Tratham, because you were part of these discussions, we had, I think, 3 in-person meetings, and then we were told that the village didn't see the point in talking to us anymore. So,
Well, that was in the context of a negotiation of some sort of solution. And what they told you was there had been nothing offered that was feasible. Wasn't that correct?
did they make a counter proposal?
My question to you is, has Mayor Quinn or Scott Gardner, have you ever reached out to them and they said, no, I don't want to talk to you and I refuse to meet with you, or I won't take your call?
No, what I said was accurate, that we were in a dialogue and they cut off that dialogue.
You were in a negotiation that was unsatisfactory, and that was the end of the negotiation?
They could have made a counter proposal.
In any event, the door has never been closed from their perspective for any continued dialogue. I think, Scott, you heard Scott Gardner talk about the desire for, more cooperative relationship, did you not?
We share that desire.
And that door is not closed. The only issue has been the acquisition piece. The operational pieces, the improvement pieces, those doors have never been closed. We can call, the mayor's on my speed dial. I'm on his. When he calls me, I pick up or I am on that phone, and he has extended to me the same courtesy. The only issues that we have had with the village are related to the acquisition and the ROFR, not operational issue communication and not capital improvement communication and how we're going to increase and better the system.
Thank you, Mr. Paul. With respect to the reference to the association, you're aware of the survey that they conducted where only 23% of the respondents supported the transfer?
I've heard of it, yes.
I'm aware of it, yes. After the mayor lobbied on the Village of Bald Head Island website as the mayor to provide those answers.
Okay.
And less than half of the association, I think that only about a third of the association actually voted.
Okay. Nonetheless, 23% of the respondents supported the transfer. Is that your understanding?
Yes, sir.
That's all I have. Thank you.
No questions.
Mr. Fair? Okay, gentlemen, we have come to the end of the day. We thank you for your testimony. Yes, and we did accomplish this in 1 week. You may be excused off the stand.
Commissioner, may I just say one sentence? I realize that the commission generally deals with matters of greater statewide import than this, and I might have an above average understanding of what public service entails. So thank you for the time that you spent on this transaction and for your consideration. We appreciate it.
Thank you for those comments. So do we have any motions? Mr. Farrell? The entry of the exhibits.
The exhibits.
I think you've already
Well,
accepted.
we identified them, but we will,
We need to move them. Let's move them in, 1 through 8.
that motion is allowed.
And Madam Chair, we had one cross-examination exhibit village. It's all cross-examination exhibit 1.
And you're moving those, that exhibit, how many exhibits? 2 exhibits?
It's one exhibit, 2 pages. And there was-
One exhibit, 2 pages will be received into evidence at this time.
Commissioner W, just for the record to be clear, since it was raised earlier in the docket, we have filed with the commission non-confidentially the spoils survey. So that spoils basis survey, that is now a matter of public record and it's been
Okay.
filed in this docket.
Thank you for filing that.
And just again, to clarify that I think exhibits 6 and 7 were confidential, attorney's eyes only.
Yes, those have been received into evidence confidentially. We'll take care.
Mr. Duffley, to the extent that it's not been entered, I wanted to make certain that we entered the summary of the amended and supplemental testimony of Michelle Boswell, Krishna Rajiv, and John R. Hinton, given provided yesterday, 3 pages, if I may.
Okay, that summary is received into evidence at this time.
I'd also like to ask, including in light of all the discussion today, but also throughout the hearing, that the commission take judicial notice of the record in the sub 21 docket.
Let me be heard on that.
Yeah.
And unfortunately, I started packing up my papers before that. So, Mr. Creech, you mentioned that to me.
Well, okay, you have your papers?
I do. So the commission has a specific rule on judicial notice. It's statute 62-65. And so I understand Mr. Creech's request not to add all that to the record in this docket. There are facts that were stated under oath by witnesses for the village and others that we disagree with. And I'm sure there's facts that our witnesses stated that other parties disagreed with. So if the commission took judicial notice of all records that were submitted in there, I'm not so sure what that means. I certainly have no objection to either party citing testimony that may have been uttered from the witness stand, and this commission can give whatever weight they want to, and if they take judicial notice of a fact, then 62-65B applies to it. So I would object to there being judicial notice of the entire record without prejudice to the clients, to the parties to cite whatever reference they think is relevant for this commission's consideration.
Mr. Creech, does that satisfy you?
If you're indicating that the testimony in the sub 21 docket as given will be,
He's saying that if you want to cite that in a brief, and we'll receive it in the brief and we'll give it the weight that it's due.
Thank you, that's sufficient.
And if the commission were to make a finding based upon that fact, then 62-65B would apply.
Okay, I think that issue is resolved. Any other issues?
Madam Chair, if I could just restate the village's continuing objections to the extent of confidential designation in this proceeding and the impact that it's had on the public's ability to participate and the ability of counsel to advise clients. Raised that a couple of times. I do think it's a potential due process issue with respect to the conduct of this proceeding and as I've indicated, I'd like to reserve the ability to see to these designation of certain materials if necessary, post-hearing.
I will allow that. Do you want to be heard?
I do. I've been thinking about that. At such time as the village's actions are no longer as a competing bidder, objecting to and opposing the transaction, and the dynamics of a lot of that information is completely and totally different. But so long as there is ongoing litigation in Brunswick County and continued opposition, as they have their full right to, then we have to consider a competitive threat by a competing bidder. And I wanted to explain the assertion of confidentiality that we
Okay.
made to the state.
And I don't mean to interrupt, but all I heard Mr. Trathan arguing is the ability to make a motion to de-designate confidential information.
And he can certainly make that motion, and we would certainly respond. I have no objection to that motion being made at the appropriate time and pursuant to the commission's procedures.
Mr. Farrell?
I guess I would raise some concern about the motion, given that the parties entered into an agreement to allow documents to be shared in that manner. This commission ordered certain documents to be provided with that designation. I believe the orders on the motions to compel specifically instructed, and primarily these are short view documents, to provide those documents with that designation. Those documents have been provided throughout sub 21 and sub 22 with that designation. There's been no prohibition on the village filing a motion prior to this hearing on that issue. We're concerned about this late raised issue just here at the hearing, as opposed to dealing with it before all these documents come in. I mean, the hearing's already occurred, the closed sessions have already occurred. This motion and this issue could have been addressed before this hearing instead of in some post-hearing motion that would require us to take our focus away from trying to come up with regulatory conditions that we can all support to dealing with this additional issue. And so I would oppose and object to the allowance of this late filed motion after the hearing's already concluded on an issue that's been present since the beginning of the sub 21 proceeding. And again, we were ordered to provide documents and protect them in that fashion because these are confidential and business trade secret documents.
Mr. Trathan, do you have a response?
Yes, thank you. First, with respect to the agreement does provide the parties the ability to contest the designation. With respect to the timing, we've been trying to see how this hearing would work out. We didn't know exactly what would happen with respect to confidentiality designations at the hearing. We're hopeful that it would have been more open than it was. And so I think.
Why did you not make any objection during the hearing? If you felt like there was an issue with how closed it was, why did you not make an objection at the time that you were feeling that it was potentially too closed?
We've given continual notice of the concern. I'd like the ability to kind of reflect on this and evaluate, whether we need to pursue a formal motion.
Okay, I am going to take this motion under advisement, and I'll issue an order accordingly after I make a decision. Are there other issues holding the record open? Was there anything else, Mr. Trathan?
I hadn't actually made a motion, but I understand you want to reflect upon the conversation that we're having.
Yes, I do.
Yeah, I'm not aware of any other open issues with respect to.
There were, okay, I think public staff, there were some data requests. We were going to hold the record open.
What occurred is that there was a filing earlier this week on some supplemental information, and I think that's been addressed by Mr. Steyer's filing. It was part of the disclosures on the asset purchase agreement, and there may well, if we have questions, I'd have to review your filing, but maybe you speak to that.
I'm not aware of any open issues or any documents that have been requested that we haven't fully now provided all the parties.
You indicated earlier, though, that you would be open to discovery and supplemental testimony on that, should we have it. I'm not trying to bind you now. That's what I remember on the
I
record that we
think the
discussed.
hearing's closed. I consider the hearing closed at this point.
Okay, we'll just reflect on what the record is.
We can always reopen the record
Okay.
if need be.
No problem. Now, we'll say while we're here, of course, the public staff remains open for business to hear from anybody, any party on these regulatory conditions, any way to make them better. So,
Okay, so transcript, let's talk about briefs, proposed orders, 30 days from the transcript.
At least 30 days, maybe 45.
I was, it's funny, Mr. Trey and I have not agreed on a lot in this docket. Because I was saying, the sooner the better, I think, from our client's perspective. So, I was going to say at most 30 days. So I think Mr. Trey said at least, and I'll say at most, we'd be willing to do a shorter period of time if that would be the commission's preference. I think it's probably my client's preference, but we could live with 30 days, but no longer would be, that I would be authorized to consent to.
You all practice in front of the commission. We most 100% say 30 days and we go shorter. So 30 days from the transcript.
Thank you.
Thank you.
Any other matters?
The only other matter I might raise is we have been working with the public staff on the regulatory conditions. Our proposed conditions are in the record, so are the public staff's. I would just ask that if any other intervener has conditions they want us to consider, that we have a dialogue about it. And if we don't get those in a cooperative format, if they're just added or included in a brief or a proposed order for the first time and we haven't seen them, that we get some reasonable opportunity to address those. Again, our hope is that it would be a cooperative process to try to work through some of the regulatory condition details. But again, we just haven't seen any yet from the interveners. So I want to make sure that we have some opportunity to respond if necessary.
I understand your concern, but we have to cut it off at some point. So when the proposed orders come in, we'll have all of the regulatory conditions and we'll be able to pick and choose from those if we want to, or
Thank you.
I think we're done with the hearing though. Anything else? Okay, we are adjourned. Thank you all.
Thank you.